Welcome to Beyond Borders, the Immigration Evaluation Podcast. Whether you're just starting to explore how to add immigration evaluations to your practice, or you've been conducting evaluations for years, this is the place for you. I'm Dr. Mariella Shibley, and I can't wait to share today's episode with you. Today we have a truly special guest joining us. Raquel Aldana is the Martin Luther King Jr. Professor of Law at the University of California, Davis, and a graduate of Harvard Law School. She has taught and written extensively on issues of immigration and human rights, and on how trauma functions and sometimes gets misunderstood within immigration law. She has recently published a piece in the American Journal of Law and Medicine that's titled Adjudicating Credibility, documenting the role of mental health immigration forensic assessments. And that looks specifically at credibility adjudication and the role of mental health forensic assessments. That one's going to be essential reading for anyone doing this work. So what I love about this conversation is that Raquel brings a legal lens to questions that we as clinicians think about all the time. And that is, how does a judge read our reports? Are we writing in ways that actually serve our clients legally? And what does the law really need from us that we may not be delivering? So whether you're brand new to immigration evaluations or you've been doing this for years, I think you're going to walk away from this episode with a sharper sense of how your work lands on the legal side of the table. So let's get into it. All right. Well, Raquel, thank you so much for being here. I've been looking forward to this conversation for a while now because, honestly, your work sits right at the heart of what so many of us in this field are wrestling with every day. We spent so much time in the clinical world thinking about trauma and how to document it, how to present it, and your scholarship really forces us to zoom out and ask, what actually happens to all of that once it leaves our hands and enters a courtroom or the hands of an adjudicator? So I'm really glad that you're here, and I can't wait to get into it.
Well, I'm thrilled. Thank you for having me.
Good. Of course. Well, I want to start with you a little bit. This is a pretty specific intersection, right? Immigration law, trauma science, and forensic mental health practice. So what drew you to this research and to writing this article? Well, you wrote a few articles, but this last specific one.
Mhm. Well, I've always worked with individuals who've endured substantial trauma, both as a human rights lawyer and then subsequently as an immigration scholar. And it wasn't until recently that I always had a sense that the law was very disconnected from the science of trauma, but I hadn't really delved into it until I joined UC Davis and started to work with an interdisciplinary community that was taking a deep dive into these very, very kinds of issues. And working with psychiatrists and psychologists, it confirmed for me a lot of the things that I had been thinking a lot. The law tries very hard to adjudicate issues, to try to give some kind of repair for harms that have been done. But we get it wrong quite a bit. Our priorities and our goals are different than the priorities and goals that exist in the medical profession or in the mental health profession. But I do think there are ways where we can collaborate better, absolutely, to make it better. And it doesn't have to be across purposes. I think we can achieve multiple goals if we just simply learn about each other's worlds and try to improve our practices informed by the science of trauma and memory.
Mm-hmm, mm-hmm. Yeah, and you describe this fundamental tension in your research between what the law expects from someone telling their story and what science actually tells us about how trauma affects memory and narration. Can you walk us through that gap and why it matters so much in immigration law?
Yeah, absolutely. Especially after 9/11, Congress actually set out to define or to provide standards to assess credibility, especially in asylum cases. The context matters a great deal in that this is a post 9/11 world, and there were also a lot of narratives and rhetoric around both national security concerns and rampant fraud. And the focus became asylum in particular. I do want to set out that there was not a lot of substantiation or even deep dive into whether, in fact, it was true that there was rampant fraud and or that national security was a significant concern. And my own assessment of the issue, looking at many studies, is that neither of those two things are true. But for our purposes, it's just important to understand that that was the primary motivation. The motivation wasn't really, let's think about this in a humane way, trauma-informed way. Let's really kind of think about how to do it in a way that is scientifically sound. The purpose was really to think about how do we adjudicate these cases in a way that gets rid of the fraud and allows us to screen out the people who are telling the truth versus the people who are lying. And I think it's important to know that because the motivation, of course, drove the approach. And the other piece that is important is that it was very fast paced and it was done, Congress sort of adopted these norms without a lot of deliberation and certainly without consulting scientists and the medical profession. So what Congress did is it codified this definition that focuses on it is a totality of circumstances approach, and that's good because it's not just a single factor that determines credibility, but it does lay out the things that matter. And one of the things that matters a lot is consistency and consistency in the narration of the story. And it's consistency, not just what we call internal consistency, like the client telling the story has to be consistent all the time in the ways that they narrate the story. And then there's also consistency across several pieces of evidence. So they also have to be consistent with what others are saying, what expert reports, etc. So there's external consistency. There's also an emphasis on things like demeanor, and there's no definition of what demeanor means. But demeanor can mean all kinds of things, like are you making eye contact? Do you have a flat effect? Or are you crying? Etc. There's also an emphasis on things like plausibility that I think it's fair, which is to say, how does your story gel with what we know about context and history? And so that makes sense to me, but sometimes the shortcomings of that is that there's an undue emphasis on State Department reports as the sort of gold standard of how we assess context. And I think State Department reports miss out on a lot of things that should be relevant to questions of plausibility. And then there is some expectations of corroborating evidence, although there's flexibility there because most adjudicators understand that asylum seekers, especially given how they fled, may not have access to the kinds of evidence that can substantiate their claims aside from their own stories.
Right.
That's
Right.
how we do it, right? And
Mhm.
we can go on to talk about how we do it in the law.
Mhm.
It just doesn't gel with what we know about the science
Right.
of and memory.
Right. 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 And so when you surveyed attorneys and mental health providers about how these evaluations were actually being conducted, what surprised you more about what you found?
Well, I mean, I think in general, one of the things that surprised me is that, well, I shouldn't say this surprises me. I think it's expected that lawyers, what they're trying to do, right, is lawyers are trying to translate a story that in a way that fits the legal expectations. And so lawyers are doing their job by trying to seek forensic immigration reports within the standards that they must satisfy. And they also understand that who they have to convince is the immigration adjudicator. So they're both aware of the legal standard and they're also aware of the adjudicator's expectations. And therefore, what they're looking for is how can this immigration forensic report satisfy those expectations and that legal norm. So that doesn't surprise me that they're out there kind of trying to substantiate and advocate for their clients. But maybe what does surprise me more is that there isn't a whole lot of interdisciplinary discussions that would help bridge the gap in the ways that um, perhaps lawyers are communicating with mental health providers. So the expectation is give me what I need rather than how can we best collaborate
Right.
given the science that you know and your expertise. Maybe the role should be slightly different, not give me what I need, but how
Right.
can we best achieve this imperfect space? How can you help us understand or help explain why this particular case may not be able to fit neatly within these expectations and these norms? And how can you do your work ethically? And how can you help educate us in the
Hmm.
law and also educate the adjudicators, right, as to why there may be gaps in memory or why there may be inconsistencies or why there may be different demeanors that attach to people depending on cultural norms or even developmental issues or other reasons why there may be a particular presentation of someone who may have endured trauma that may not be consistent with expectations. And so I think what surprised
Right.
me is that the approach is more this is what I need rather than let's engage in a dialogue.
Exactly. Exactly. Yeah. I think it's something that I found myself as well that, how little um, attorneys sometimes understand about what the report of the psychological evaluation is telling them versus hoping that it helps their case.
Yes, exactly. And I understand the lawyer's perspective. The
Sure.
lawyer
Of
says we're
course.
advocates, we need to get this done.
That's right.
But in doing that, lawyers are making mistakes. So for
Mhm.
example, one mistake is that lawyers are sometimes fixated on seeking a mental health diagnosis. And
Yes.
typically they want a diagnosis of PTSD, right?
Yes.
Rather than asking, um, is it helpful for us to think about a diagnosis of PTSD in this case? And how should I interpret the results if it turns out, right, that a PTSD diagnosis doesn't derive? When you, if you were to open it up in this way, then perhaps the evaluator would do more to include explanations, right? Rather than, no, there is no diagnosis of PTSD flat in the report, right? And therefore, the presumption that if there is no diagnosis, it must mean that there was no trauma, which is
That's right.
completely wrong, right? So I think those are the kinds of things that we get wrong. And I understand why, but we need to change how we approach this space.
Yeah. 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 Yeah, that is the one thing that I found like most salient, right? It's just like the data suggested that the absence of a PTSD diagnosis can, actually undermine a case, even though the science is so clear that not everyone who experiences trauma develops PTSD.
Yes.
And I had a phone call with an attorney yesterday whom, I had to explain that, how we arrive at a diagnosis and how we follow certain criteria.
Mhm.
And if it's not there, it's not there. And, and that doesn't mean that the person is not struggling or didn't struggle.
Mhm. Yeah,
So
exactly.
yeah. Um, I want to dig into the credibility piece also a little bit because I think it's where so much of, can go wrong and where the stakes are, oftentimes the highest for clients. So adjudicators are looking for you tapped into this a little bit, this sort of consistent, linear, detailed narrative. And trauma is precisely what disrupts that.
Mhm.
So how are evaluators and attorneys actually working around that contradiction, or how can they work around that contradiction in practice?
I mean, I think the first thing, right, is that there needs to be more training. Um,
Yes.
and so I'll get to the specifics of this, but one of the things that we discovered from we did a survey, and so the last piece that we published on adjudicating credibility in immigration cases, we were interested, for example, in even understanding what norms people were applying and what they knew, what was their working um, uh, sort of set of assumptions around this discussion. I learned for the first time that there isn't even a credibility term in your world. It's malingering,
That's
right?
right.
And so I suddenly was, encountering this term, and how do you define it? How is it different? So then we became very interested in understanding, do lawyers know? And vice versa, do mental health professionals understand the differences between malingering and credibility? So sometimes even just are we speaking about the same terms is a really important consideration. And the other thing we discover, for example, is that there is already a gold standard in international law called the Istanbul Protocol, which has been used to mostly document instances of torture and cruel and inhuman treatment, but increasingly has become a really important uh, tool that can be employed in asylum cases. We discovered through our survey that lawyers, especially, have very little understanding that this document even exists. They have much less any understanding of its content. So that was
Right.
shocking to me. And so how can forensic immigration reports help? Um, I think they can help by even educating adjudicators on these important differences between what is actually the role of a mental health provider. The Istanbul Protocol clarifies that a mental health assessment should not actually be drawing conclusions on credibility. That's a legal
That's
determination.
right. Yeah,
And it's not a mental health determination. And
that's
in fact, whether someone is lying or not lying, it's not really something that mental health professionals are supposed to be doing at all. It's the assessment is much more about congruence between how a particular client is presenting in terms of their symptomology, right, in the present, and whether that is consistent with instances of trauma. And that actually sometimes can include memory issues, right?
right.
Gaps
Right.
in memory or how memory is presenting these sort of, as you suggested, that trauma interrupts certain ways that memory establishes itself. And we know how those things are interrupted. And so being able to document the reason this client, right, can't have recollections or may have, outsized recollections of certain things and not other things is actually consistent with
Right.
trauma affects memory. So
Correct.
the project is very, very different and can be helpful very much to explain to an adjudicator that in fact trauma is likely to have happened because what the mental health expert is examining in the present, right, is very consistent with someone who has endured trauma from a scientific perspective.
Right.
That may or may not be consistent or may not be linear, right? And all of those things. And so I think where immigration forensic reports can be very, very helpful is to help bridge this gap in understanding between law and science.
So I want to come back to this, but I also want to go back a little bit to something that you say. You said about the concept of malingering and how it intersects with credibility in ways that that are misunderstood across both professions, right? So
Yeah.
your data showed that nearly half of mental health respondents weren't sure that there was a meaningful difference between malingering and credibility.
Yes.
So, so for clinicians who are doing this work, can you explain why that distinction matters and what's actually at stake when it gets blurred inside a forensic report?
Yeah, exactly. I mean, so my understanding of malingering is that there may be sometimes clients who are maybe exaggerating symptomology, right? And in our piece, we try to explain. And by the way, in writing that part of the report, very much relied on expert psychologists and psychiatrists to kind of help me understand this difference, right? So when you're exaggerating symptoms, there could be multiple reasons why you're exaggerating symptoms.
That's right.
One reason could be mental health, related. You might be someone who could be someone has multiple personalities. You could be. There's so many mental health reasons why you exaggerate symptoms.
Well, the most basic of which is anxiety that you won't believe them.
Yes, exactly. And I was going to also say, right, there could be cultural reasons. Like
Yes.
we know that um, Black women, or I'll use me as a Latina woman. Sometimes I feel like I have to speak louder, for lack of a better word,
Yes.
or that I have to assert who I am in order to reduce bias, in
Yes.
order to be taken seriously, right?
Mhm.
So there could be past experiences of being invalidated, of being ignored, or being rendered invisible that could explain why I may be uh, doing something, right? Because I haven't been believed in the past. That has nothing to do with whether or not you're lying, right? So I think there's so many reasons that a mental health expert who is attuned and sensitive to these other explanations, right? Um, could help inform in the report, right? That could allow an adjudicator who is open to the possibility of understanding this in a deeper way, that in fact, malingering is not indicative always. There could be, but it's not always indicative, right? They're not lying necessarily. There are other
Right.
reasons why malingering might be happening.
Right. Right. And one thing that I found interesting in the study was that it found that the vast majority of clinicians are relying on behavioral observations, things
Yes.
like eye contact and nervousness, movement, evasiveness, as part of how they approach credibility. But the scientific literature raises real questions about whether those indicators should be used that way at all. So, what should clinicians be making of that finding?
Yeah, so I mean, I think that was interesting because that's where there is more convergence around adjudicators and mental health providers. They're both over relying on what law calls demeanor and what you
Yes.
call behavior, right? It's the same thing. It's where we are making assumptions about, and we're being overly optimistic about our ability to tell, right, whether someone is lying based on these behavioral or demeanor indicators. Because you're right, the science says actually that's not true. We aren't that good at
Right.
detecting these things through conduct. And so one of the things mental health providers should know is just self-reflect on that and say, oh, maybe that's not what I should be doing. The other sort of important observation about this is that the least used
Mhm.
method is um, is psychological testing, right?
Yes.
And those tests could actually be better, not perfect, but better indicators of certain things that you're trying to measure. So
Mhm.
I'm not in your field. You know this area better than me, but just in speaking to psychologists and psychiatrists, I understand that there are these tests, including malingering scales and other kinds of things that have more reliability, scientific reliability,
Yes.
than just observation, right? They're
Yeah.
not perfect, but they're better.
Yeah.
My One of the surprises for me of our survey reports is how few mental health uh, experts who are doing these immigration forensic reports are actually doing these tests.
I was so shocked by that as well, and I did wanna ask you about that as well, yeah, because it was a significant proportion of mental health providers who they said they weren't familiar with validity scales or effort testing or didn't
Yes.
find them important.
Yes, that was shocking to me,
It
but it was shocking, except, right, that um, when you dig into the profile of who is doing immigration forensic
Yes,
reports, right, then it makes sense. Because
absolutely.
what we learned is that, in fact, psychologists and psychiatrists are a minority, that
Mhm.
most of the people who are doing these kinds of reports are actually trained as sometimes family therapist or, you know,
Social workers,
work
counselors.
counselors, and so part of the question is, right, do they even have this training? And so I think part of it is that there may not be adequate training in these kinds of tools.
100% agree, yes.
Right. And
Yes.
the reason why this world is so diverse in terms of who's participating in it, right, is because there is really no. Well, we explain that there is no like market for it because there is no expectation. Well, there's a market, there's a need. What I mean is there is no paid market for this because the government doesn't pay,
Right.
and a lot of the clients who meet them are either low bono. Sometimes they're expecting these to be produced pro bono. Some are paying clients, but for the most part, this is a space where we need a lot of mental health providers to do this out of kindness and grace. And many of them said to us that they find that frustrating because they have a lot of their own debt to pay for the studies that they have undertaken. And so a lot of times the expectations of low bono and pro bono also limits the who is participating. Obviously, this
Right.
is true across the board. But Physicians for Human Rights is an example where a lot of medical doctors are participating, but we don't have an equivalent of Physicians for Human Rights in the mental health space. I would love to see like psychologists and psychiatrists stepping up to figure out how to participate much more in this space, given the limitations of funding and pay or publicly paid funds to be able to engage in this kind of work.
Right. Yeah. Yeah. Which is actually just to plug in my nonprofit, but it's just why
Yeah,
I founded the nonprofit, right? So we could subsidize the cost of the evaluations for people who can't afford them, subsidize the cost of training for mental health professionals who need some help with that, and pay mental health professionals what they're worth, basically, for
thank you
this
for
type
doing
of work. Yeah,
that.
it's a steep uphill battle, right, to get there, but I'm very confident that we'll get there. But along those same lines, what you're saying is so true that it's specific groups of people that are typically drawn to this type of work. And so that brings me to the issue of advocacy.
Yeah.
And that is something that is so important when it comes to report writing, because this is the work product and this is what the adjudicator is going to first see, unless they end up in testifying in court, the mental health professional. So along the lines of these issues around malingering and assessing for credibility is, I think, a lot of mental health providers have their heart fully in it, and sometimes that transfers through into the report. Do you have any thoughts about that? Or even when you were talking about educating the adjudicator, how to do so in a way that doesn't come across as the mental health provider trying to convince to the adjudicator to advocate for the client?
Yeah, I mean, it's a great question. It's a tricky space, right? And we talked a lot around the ethics of these reports because one of the things is, are you as a mental health provider, um, especially when you're being paid, right, by either the client or the lawyer, are you by virtue of that an advocate? And if you are, is that, does that raise ethical considerations, right, for your profession? Because in contrast to the lawyer who's representing the client, in fact, your role is not to advocate. Your
Nope.
role
Exactly.
is to
Neutral.
render, right, to
Mhm.
render a scientifically sound report. Now, that doesn't mean, and I think it's important to say this, that doesn't mean that you don't become um, an advocate for the science, or maybe an advocate for improving the process, or an advocate for improving understandings across disciplines. I think those are very different projects, right? So, for example, if you are someone who's deeply trained in understanding how children experience trauma, right, then I think it is your role to say, boy, lawyers could really use some deeper education on this so that they're not making the kinds of mistakes that are continually made. So in my report, I am going to be very thoughtful and careful in transferring my knowledge in a way that is helpful to this child, right? To me, that's a very different project because in some ways you are advocating for an outcome, but the outcome is still very much grounded in scientifically sound understandings that you have that the law misses. Right. So I think that's where I see the difference. It's like I do think that you can become someone who is invested in a project and an outcome that in the end is actually helpful to children or is actually helpful to asylum seekers without necessarily compromising the ethics of your neutrality in the individual report.
Right, right. And focusing more broadly as opposed to this
Yes.
one person, this one client.
Correct.
So, focusing on the people who make the final call, right? So the adjudicators, because I think understanding how adjudicators think or how they're perceived to think is something that clinicians don't always get enough exposure to. I want to take a moment to share a way that you can get more direct support from me. I offer one-on-one consultations for mental health professionals doing immigration evaluations who are looking to refine their skills, strengthen their reports, and feel more confident in their clinical decisions. If that sounds like something you're looking for, you can find more information in the show notes. Now let's get back to the episode.
Mhm.
So, both attorneys and mental health providers in your study perceive immigration adjudicators as having almost no working knowledge of trauma science. Over 80% of attorneys said that adjudicators were either not knowledgeable at all or only slightly knowledgeable. If that perception is accurate, what does it mean for how clinicians should be writing and framing their reports?
Yeah, it's a great question. Well, I think it argues for, or at least it suggests that the reports should be doing a lot more to educate the adjudicators on key points. Um, it also, I think one of the things that I forgot to say in your earlier question is could reports hurt rather than help, including by crossing lines into advocacy? An example of this would be that you should not actually be drawing conclusions in your report that are displacing what the role of the adjudicator is. In the end, it's the adjudicator's job to decide issues of credibility as a legal matter. In the end, it's the adjudicator's job to decide issues of eligibility. Is someone eligible or not for asylum? That's the adjudicator's job, and you actually do a disservice to the client if you provide opinions of your own on things that you shouldn't be doing. That's not your turf. And you actually, I think, end up hurting the client because adjudicators, they may not know the specifics of the science of trauma, but they know that it's not your job to be telling them whether or not a client is credible or whether or not a client has experienced trauma. Those are legal determinations.
Right,
So
right.
knowing that, I think, is really important. So instead, I think your job is to sort of say, okay, I know, maybe have empathy for the adjudicator, right? The adjudicator is busy. They have to make decisions in a ton of cases. They're trying to make their best judgment. Don't assume that they're acting necessarily in bad faith, but they have to decide. And there may be a client who's presenting in a particular way where you could do a lot to explain to them, why the way that they are presenting is actually scientifically consistent with past experiences of trauma, right? And I think kind of taking the time to explain that, or even saying, there's actually indicators of malingering, but here's what I think is happening, right? And explaining that scientifically. So I think it's important to do that. I also think it's important to do it in a way that is not too scientific, right?
Right.
You're writing
To the
um,
reader.
to the
Hmm.
reader. And
Hmm.
so I think it also hurts the client if suddenly you become very medically
Of course.
in your language
Using
or
jargon, yes.
again,
Hmm.
and you want to sound really smart and you talk about these psychological testing and use whether it's statistically significant. That's not how you want to write these reports. And
Exactly.
it's you have to understand your audience, you have to understand their job, what they're being asked to do, and you have to understand your job and your role and do a really good job of saying, how can I help them make the
That's
best
right.
decision that is trauma informed and science
Yes.
informed?
Yes. Yes. And there's also something that I want to make sure that we don't skip past. And So your data suggested that prior criminal history is a primary factor for which adjudicators are perceived to adjust their credibility assessments.
Yeah.
And you flag that as potentially reflecting a negative bias.
Yeah.
So what's something that clinicians should know about when they're working with clients who have a criminal history?
Well, first they should know that it is a huge bias in
Mm,
the adjudicator's mind and that it's going to be very relevant because sometimes a report can help not by what it includes, but what it leaves out, right? And so there's also a lot of omissions. And I actually think like not saying thinking, oh wait, I know there's a bias against crime, so I'm just not going to put it in my report. That's a mistake because the bias is going to be there whether or not you address it. And so if you could explain, right, if, for example, and I'm just guessing here, if there is a mental health diagnosis that could explain the criminal behavior, I think it's important to say that. It may not always change the outcome, but it does edify or help with the understanding. It could evoke more empathy and compassion in the adjudicator to
right.
understand, right, the circumstances and the context in which some of these criminal conduct may have taken place.
Right. Of course, that's if it's relevant to the case.
It's relevant to the case. Yes. Yes. I mean, it is true that to some extent it is always relevant because um, there's discretion always in whether or not to grant asylum or whether or not to grant another type of humanitarian visa. And sadly, there is sort of this deservedness assessment going on. Does this person deserve? So they're even when they are otherwise legally eligible, um, in asylum cases, they can decide a no because the person is viewed as not deserving because of other conduct. So to some extent, it's always relevant. Sometimes it is relevant in the do do I want to be able to say to the judge, I understand that there is this criminal history, but understanding um, some of the broader important considerations can help you decide whether to exercise grace. I think
Right.
that's important.
I guess what I'm saying by relevancy is what's relevant to us as mental health professionals. So if I'm doing an asylum evaluation to assess how a person was harmed, how they were traumatized, their fear of returning, then their criminal history may not, it may be relevant, but it may not be. And
Got it.
so
Okay.
we don't do a thorough, just talking about every nitty gritty little detail of their lives when what we are there to assess is specifically this psycho-legal question. How did the trauma affect them? And are they still afraid to go back? And so
Yes.
now if the case then opens up another can of worms, then they might be referred back to us to maybe help explain their criminal history within the context of their mental health status and their personality characteristics or whatever it is, right? And so that's when
Got
it becomes
it.
really
Yes.
relevant. But
Yes. I understand. I was looking at it from the legal side.
exactly, exactly, exactly. So, so I want to shift gears a little bit because I think one thing that I often hear from clinicians is that they feel like they're kind of writing in a vacuum, not really understanding the legal framework that their report is walking into. So, are there any, or what are the legal standards or concepts that evaluators should have at least a working understanding of?
Mhm. No, it's a great question. I mean, I think they should understand how credibility is assessed, right? That's a starting point, and therefore also understand how science could help the adjudicator understand when their expectations are not going to be met, but they should still not conclude necessarily in a particular way because there are these other explanations they should be aware of. They should, you know, they should be somewhat familiar with some of the things that have to be established. So, for example, in because overwhelmingly these immigration forensic reports are used in asylum cases, but not exclusively. But that's why I'm focusing on asylum. But so, for example, in asylum, you have to establish persecution, that persecution happened. You also have to establish that there was a nexus between the persecution and the reasons for the persecution. Usually the nexus has to be to a protected class, the person being a member of a protected class, like, for example, the ethnicity, race, etc. And so knowing that can be helpful because, for example, what does persecution mean in the context of law? Can help the adjudicator decide, even though the adjudicator is its job is not to affirm um, the factual veracity of things, right? The adjudicator can um, help provide context. I'm sorry, not the adjudicator. The mental health forensic report can help provide context that might help the adjudicator assess whether persecution happened, because persecution can be on the basis of economic factors, it can be on the basis of discrimination, it can be on the basis of um, torture, it can be on the basis of FGM. I mean, there are all of these harms that could give rise to persecution, and if you understand that persecution is a high threshold that requires a documentation of harms, then your report can at least be mindful of that and make some contribution to say, this is what I learned, right, from my assessment with the client. These are the kinds of things that I learned. Another thing I will say, right, is that a good mental health evaluator or provider might be able to establish rapport and trust in ways that may not have been present, in the adversarial process, right? So suddenly you discover maybe that there was profound sexual trauma that wasn't disclosed, right? And if that is inconsistent with what is in the legal record, but it came up in your setting, you can explain very much some of the cultural or mental health reasons that people don't disclose sexual abuse. Or sometimes you actually try to forget about it, right, as a mechanism of survival, or you don't disclose it because of the fear of stigma. If you're someone who got to a level of trust with the client where that story comes up, and you simply say in your narrative there was sexual abuse or there were indicators of sexual abuse, and it's not present in the legal documents, right? And you don't explain why it
Hmm.
is possible that the story may have been suppressed earlier,
Hmm. Hmm.
that can hurt the client.
Exactly.
And it's not advocacy to take the time to say, this is why here's the scientific explanation that I can provide, or the mental health explanation that I can provide as to why it only came up in this context.
Yeah, yeah. And I think, in my opinion, I think understanding the legal standards and the concepts is really important for the evaluators to give context to the case. But something that you had mentioned before, we need to stay in our own lane, right?
Yeah,
So the mental health professional is not there to determine whether there was persecution or not. They are
correct.
not there to describe in detail the persecution.
Correct.
um, it's really the focus is on the impact on the person and their mental health and the post-traumatic symptoms, all that stuff. And it's very easy to just go down a rabbit hole with that for the evaluator to try to assess both, right? The legal standards and the psychological impact, which, that's not in our scope of practice.
Yeah. Yeah, I agree. I do think the corroboration piece, because I think it gets conflated with the mental health and the medical forensic pieces that can be a lot more corroboration to the facts, right? But I think, for example, if a mental health evaluator discovers something that is not documented in the story, like, I do think it's helpful for the evaluator to say to the lawyer, "Can you help? Can you send me the narrative?"
Yes. Mhm.
Because if something comes up that it isn't in the narrative, that that the lawyer provides to you, a good mental health evaluator might say to the lawyer, look, this came up and my job is not to tell you whether in fact it happened. I do think maybe I can uh, give you my psychological assessment of whether the client is presenting in a way that is congruent with that past traumatic experience. But you might also consult a doctor to see if a doctor could give you a medical assessment that could corroborate the story, right? And I think I would love to see much more dialogue, right? In an ideal world than simply, here's what I need from you, which is what the lawyer says to the mental health provider. The mental health provider struggles to provide the best that they can, and they, issue the report, and then the lawyer reads it and says, this is not what I need. And then sometimes the lawyer, because we asked, although it didn't come up in the piece that we wrote, we are writing a second piece on this.
Hmm.
We asked the mental health professionals to tell us how many times lawyers ask them to rewrite things.
Mm.
That's
Great
I don't.
question.
Yes, but we learned that it's more frequent than
Yes.
not, right?
Hmm.
And that gets into tricky areas of the ethics of that.
Yes.
Is to what degree should you let the lawyer edit your reports?
Correct.
Yeah.
Yeah. Yeah. Oh, I'm looking forward to that second study. Yeah. Um, so uh I was gonna ask something, but I guess you just kind of answered it, and it is kind of like the most common question is just, um things that in reports that backfire legally even when they're clinically accurate. And you kind of talked about how you have to explain it, right? If there is an inconsistency, if you're gonna add something that's new, that's very accurate, that's very, valid, but it's the nexus, right? It's just tying it into explaining why this is new and not just dropping it there and being like, oh, well, now we've got this, and
Yes.
right. But conversely, what do you think is the most or one of the most underappreciated things that a well-written psychological evaluation can do for an immigration case?
I thought about that a lot because, I have a tendency of thinking empirically, do I know how to answer this? But I will say that I've had enough experience in this space that I can make an educated guess about what is important. I will tell you one thing that your profession should know is that they make an enormous difference in outcomes. This is separate from our own study. Separate from our own study, that there was a study done by Nermeen. I wrote her name down so I make sure that I got it right.
Was
It's
it the
Nermeen.
BIA study? The one done with the Board of Immigration Appeals?
No, this one actually was a study that took data from Physicians for Human Rights from
Oh,
2000 to 2018 and looked at over 5,000 cases to decide whether the presence of a forensic report was changing the outcomes. And it showed that the approval rates for cases that had a forensic report went from 42% overall approval rate to 82% overall during that period of time. So it makes a big difference. So I think that alone, that the fact that it makes such an enormous difference in the outcome of cases is important. But I think another difference that is making that is harder to measure, but it is um, making a difference in validating the trauma that feels like um, when the the stakes are so high and the person who is testifying about their victimization doesn't feel like they have um, someone in their corner, right? Kind of, I think there's some like really emotional and powerful things that can happen from being heard in a way that is very different than how you have to tell the story, even to lawyers, because I think this is really important because even lawyers who are advocating for the client have to think about how, do I believe this client? Is this client credible? Am I going to be able to convince the adjudicator? And inevitably, we end up engaging in adversarial like, we shouldn't, but we end up second guessing the client a lot, forcing them into trying to remember facts, saying to them, but you earlier you told me this. Well, which one is it, right? And I think the reasons we do that are well intended. We're working in a system that is very fraught, and we have to make them credible. Whereas the mental health expert, right, is much more trauma informed and isn't functioning in those confines. And I think actually one of the side effects of this process is that I don't have any data to prove this, but that I hope it can be useful to the client precisely because the ways of engaging with the client are different, and because there could be scientific ways of being with the client, right? Not as an advocate, but as someone who can provide an expert guidance that can explain the client to this space that is very adversarial. So
Yeah.
I think there is that counterbalance that is underappreciated as well.
Yeah. Yeah. Yeah, and I guess that goes in line with, your study found that mental health providers reported adjusting their approach considerably based on cultural factors like
Yeah,
gender, language, trauma type, even. But both attorneys and clinicians perceive the adjudicators as doing almost none of that, right?
yeah,
Cultural factors specifically were rated as the least adjusted for by adjudicators, but
correct.
the most adjusted for by clinicians, which is what you're talking about.
Correct. Yes. So it's a more humane space. I mean, I think in my
Yes.
ideal world, how would I change the law is I would leave out, actually, I would try to get the interviewing of clients to be done by trauma informed experts rather than the lawyers and the adjudicators. And maybe we have a video of it, or maybe we have another way but just forcing the client to have to repeatedly tell a story and narrate a story. Victimization is the worst thing that you can do to them, right? In the context in which they know they're being scrutinized. I mean, how
Right.
traumatic is that?
Right, depending on the context, for sure. Yeah, yeah, yeah. Um, so if you were advising a clinician who just got their first, say, asylum referral, what would you tell them to do before they even meet with a client?
Well, one is don't do it alone. Reach
Hmm,
out to people with a lot more experience than you, and it's, educate yourself a bit
I
before
see.
you
So
do.
this is assuming that they're new and they haven't been trained. So you're emphasizing how important training is in this area.
Yeah, absolutely. I think they have to do that. I think it might be helpful to talk to the lawyer too and negotiate a little bit the expectations
Yes.
to set the stage and the tone,
Mm-hmm.
and to understand that they're not just there to do a job for the lawyer, but also to uh, insert themselves as professionals so that they understand, well, what are the desired outcomes and why you're asking for this. And I think that what you bring to the table could help the lawyer also maybe adjust their own expectations about what they think would be the most helpful. So I think maybe even before you meet with the client, it's just meeting with the lawyer, that in a broader conversation, not just what do you want from me, but more like what are your
Yes.
goals in the case. And
Well, I think I would say, like, what do you want me? What question do you have that you're hoping I would be able to answer?
correct.
Is
And
typically my
yeah,
go-to, right?
okay,
Not
that
what
I
your
like that.
goal is, because I might be, persuaded by that a little bit because I want to please you, because I want to get more
Got it.
referrals.
Okay. Yeah, well, that makes sense. And I think we're trying to say the same thing, and I was more artful in the way that I'm suggesting it. But I do think it's important for you as a mental health provider to understand that you are a player in this, but you're not just an agent of the lawyer or of
That's
the
right.
client. You have a role, and you there could be convergence in interest convergence, and actually it could be 100% interest convergence. But the way and the methods, you get to drive that. And that you also have ethical things that you need to sort of take into account that you should probably explain to the lawyer before you even do the evaluation.
Exactly. Yes. Yes. Any final thoughts or anything that you'd like to leave our listeners with before we wrap up?
I mean, maybe just to say that, like right now we are in a really difficult uh, time, and it's not normal. There's a lot of abnormal things happening in the adjudication of this space. But when we began this project, it was really an aspirational project of imagining a much better space in the future. And I just want to remind us that we have a role to play, including, right, continually working towards the aspirational space. Uh, I do think in this space we're going to need legal reform to get us to where we need to go. Right now, it feels like it's impossible to think about legal reform, but I do think individually from where we are making a huge difference. So that's one thing I will say. It's that. The other one is don't do it alone, and align yourself with others who are in the space, because one of the things that was the most joyous for me um is connecting with others who are doing this. And I learned so much, and I realized how much depth and how much thoughtfulness there is already with a lot of professionals who are working in the space. Because otherwise it can feel very heavy because the work is so.
Yeah.
Working with others who are doing it is can be very, very joyous. So
Yes.
I want to leave us with that as well.
Yes. And I want to quote my dear friend and colleague, Lynn Moore, who always says, we shouldn't worry alone. And
Yes, I
it's,
like that. I like that,
yes.
Mariana. So in that spirit, I'm full of gratitude to you for what that you're doing for this interview and for your nonprofit. It brings me joy to know that you're doing this work.
Well, thank you. This has been such a rich conversation, and I know that our listeners are going to get so much out of it. So thank you so much for sharing your expertise and your time with us today.
You're very welcome. Thank you so much. Take care.
That was Professor Raquel Aldana, and I hope that you're sitting with some of what she shared, because there's a lot to unpack here. A few things that I come back to are the idea that our reports should be educating adjudicators, not advocating to them. The finding that the presence of a forensic report increased approval rates from 42% to 82%. And her reminder that even in a system that is adversarial by design, what we offer our clients, being heard by someone who isn't scrutinizing them, actually matters in ways that are hard to measure but very real. So if this conversation sparks something for you and you're wondering what the next steps look like, whether that's getting trained, finding community, or figuring out how to have better conversations with the attorneys that you work with, I want you to know that there are resources and people who can help with all of that, so you don't have to figure it out alone. And links to Professor Aldana's published articles are in the show notes. If you found this episode useful, share it with a colleague who's doing this work or thinking about it. And as always, thank you for being here and for taking this work seriously. Thanks for tuning in. If you loved this episode, I'd love to hear your thoughts. Leave a review or shoot me an email. I'll see you next time.